These permits are valid. You are interfering with a legal operation.
I don't care about your permits. Get off my land. That's enough.
Richard Voss's voice was cold and calculated. Your land was appraised at $9.2 million. I'm offering $500,000 cash, closing in 30 days. This is fair for the risk involved. Like offering 5 cents on the dollar could erase what the deed proved. Since 1977, like 47 acres of prime commercial land were worth less than a used car. What he didn't know. Where he admitted using harassment to force Martin Kowalski and Sandra Hewitt to sell cheap. The forged easement he backdated to 1985 that he created 3 weeks ago on his personal computer. And the financial records proving he'd made $14.7 million. Stealing land from farmers who couldn't afford to fight back, Richard made the mistake every predatory developer makes. Assuming the heir who inherited farmland would be too intimidated by police calls and legal fees to defend his property, he assumed wrong. This is the story of how a developer lost everything and went to prison because he couldn't answer one question. Why does the metadata show you created this 1985 document 3 weeks ago? Because property law doesn't care how many people you bullied before. It cares about evidence. But let me start from the beginning. Before we dive into, I'd love to know where you're listening from today. The sheriff's deputy knocked on my door. At 7:14 a.m. on a Tuesday in late September, 4th time in 6 weeks. I opened the door already knowing what he was going to say. Morning, Mr. Daniels. We received a complaint that you're trespassing on HOA common property. I need to verify you have permission to be here. I held up my phone, screen showing the deed recorded with Monroe County on March 12, 2019. Deputy, I'm Jake Daniels. This is my land. I inherited it from my grandmother 7 years ago. 47 acres. I own every square foot. There is no HOA common property on this parcel. Deputy Martinez's name tag, Reed Martinez, looked uncomfortable. Sir, I'm just responding to the call. The HOA president says you're occupying land designated as community green space under a historic easement. The HOA president is lying. The Meadowbrook subdivision was built on my western boundary in 2018. Their HOA has zero claim to my land. There is no easement. Never was. Do you have documentation? I pulled up the survey on my phone, showed him the boundary lines, the parcel number, the legal description matching my deed. He studied it for maybe 30 seconds, then sighed. Mr. Daniels, this is the 4th time we've been called out here. You want to file a complaint for false reporting? Would it matter? Probably. Not, but it's an option. I didn't file. Not yet. My attorney had advised me to wait until we had an undeniable pattern 5 or 6 incidents minimum then. File everything at once and request a restraining order. Martinez walked back to his car, wrote something in his notebook, and drove off. Stood in the doorway of the old farmhouse. Looking out at the 47 acres my grandmother had left me, felt the anger building again. This was my land, and Richard Voss knew it. My grandmother, Dorothy Daniels, bought this property in 1977 for $18,000. 47 acres of flat farmland on the eastern edge of Monroe County, about 12 miles outside the city. She and my grandfather had grown soybeans and corn here for 30 years. When he died in 2004, she kept farming it herself, leasing it to neighbors, managing it from the old farmhouse where I now lived. She died in March 2019, left the entire property to me in her will. At the time, it was worth maybe $150,000. Farmland, zoned agricultural, no utilities except well water and septic. The house needed work. The land needed attention, but it was mine. I'd always loved this place. Spent summers here as a kid, helped Grandma with the harvest, learned to drive a tractor on these fields when I was 12, so when she left it to me, I didn't sell. I moved in, renovated the farmhouse, kept leasing the fields to local farmers for soybeans. It was peaceful, quiet. Exactly what I'd wanted after 15 years in corporate finance burned me out at 30-6. Then, in 2022, everything changed. The city approved a massive highway interchange. 3 miles west of my property, Interstate 94 expansion, connecting to the new industrial corridor, Suddenly, land that had been worthless farmland became prime commercial real estate. Developers started circling. In 2023, the Meadowbrook subdivision went up on the land directly west of mine 80 homes. $400,000 to $600,000 each, complete. With an HOA, governing covenants and common areas, the development stopped at my property line. My 47 acres remained farmland, now sat between Meadowbrook and the future I-94 interchange. Perfect location for commercial development by January 2025. A regional developer named Hartman and Associates approached me with a preliminary offer. $8 million, contingent on appraisal and rezoning approval. Appraisal came back at $9.2 million. Rezoning had already been approved mixed-use commercial, retail, office space. Light Industrial.I was considering Hartman's offer when Richard Voss showed up in May. Richard arrived on a Thursday afternoon, driving a black Mercedes S-Class with dealer plates, the kind of guy who wrote off luxury cars as business expenses. Mr. Daniels, I'm Richard Voss, president of the Meadowbrook, in principal at Voss Development Group. I'd like to make you an offer on your property, I invited him in, listened to his pitch. Your land is perfectly positioned for the I-94 corridor development. I'm prepared to offer you $500,000 cash, closing in 30 days. I stared at him. My land was appraised at $9.2 million 3 months ago. You're offering $500,000? The appraisal is speculative. Development isn't guaranteed. There are environmental concerns, zoning hurdles, infrastructure costs. $500,000 is fair for the risk involved. Hartman offered me $8 million. Richard's expression didn't change. Hartman doesn't have the local relationships I do. The project will get tied up in county politics for years. I can fast-track approvals. My offer reflects the actual risk. It's worth 20 times what you're offering. Richard smiled, thin, cold, calculating. Mr. Daniels, I've been developing land in this county for 15 years. I know what things are actually worth. This is a generous offer. I'd encourage you to take it seriously. I'm not selling. The smile disappeared. You should reconsider. Holding land you can't develop is expensive. Taxes, maintenance, liability. And if the corridor project stalls, your land goes back to being worthless farmland. I'll take my chances. Richard stood, buttoned his jacket.
Suit yourself.
But opportunities like this don't come around twice. He left. I should have known what was coming. Through farming contacts, I'd heard stories about Richard. 3 neighboring properties sold to Voss Development in the past 2 years, all from longtime farmers. Decided to retire after facing code violations, permit delays, and harassment complaints. One farmer told me his mailbox got knocked over 6 times in 2 months. Another had the fire marshal show up 3 times for anonymous complaints about burn barrels. All of them sold to Richard. For below market prices, I thought I'd be different. I had documentation. I had resources. I'd worked in finance for 15 years. I knew how to fight. But 2 weeks after Richard's visit, the first cop showed up. Deputy Chen arrived on a Saturday morning, June 8th. Sir, we've received a complaint that you're trespassing on Meadowbrook. HOA, common property. Can you provide proof of ownership? I showed him my deed. Explained I'd inherited the land 7 years ago, that my grandmother had owned it since 1977, that there was no HOA involvement, that the entire 47 acres were privately owned. He apologized, said he'd make a note in the file, and left. I thought it was a mistake. Someone in the HOA office mixed up parcel numbers, saw my property on a map adjacent to Meadowbrook, assumed it was part of their community buffer zone, but then it happened again. June 22nd. Different deputy, same complaint. HOA says you're trespassing on community green space protected under a 1985 easement. There is no easement. My grandmother bought this land in 1977. She owned it until she died. I inherited it. It was never part of any HOA or development agreement. I showed the deed again, explained again, as the deputy left. July 10th, 3rd visit. Another deputy, same story. Sir, the HOA president insists this land is designated community green space under a recorded easement. There is no easement. Pull the county records. You won't find one. My family has owned this land for 48 years, continuously. Never sold an easement. Never granted access. Never signed anything with any HOA. Do you have documentation? Proving that? I have the deed. I have tax records going back to 1977. I have survey maps. What more do you need? The deputy shrugged. I'm just responding to the call, sir. By the fourth visit, Deputy Martinez, on that September morning, I understood what was happening. Richard. Voss wasn't confused. He was harassing me, creating a paper trail that suggested my ownership was disputed. 5 sheriff visits in 3 months would show up in title searches. It would scare off buyers like Hartman, cloud the title, make the property look risky. And then Richard would swoop in with another lowball offer. I know there are title issues, but I'm willing to take the risk. $600,000 final offer. Classic pressure tactic. Except I wasn't a 70-year-old farmer who couldn't afford a legal fight. I was 43, had money saved for my finance career, and I was stubborn as hell. I called my attorney, Paul Greenberg. That afternoon, Paul had handled Grandma's estate transfer 7 years ago, specialized in agricultural property law, and knew every trick developers use to acquire farmland on the cheap. Paul, I need advice. The Meadowbrook HOA president has called the cops on me 4 times in 3 months, claiming I'm trespassing on my own land. I've shown every deputy my deed. They leave. Then another call comes 2 weeks later. Who's the HOA president? Richard Voss. He's also a developer. Offered me $500,000 for land appraised at $9.2 million. I refused. 2 weeks later, the cop calls started. Paul was silent for a moment. It's not a coincidence, Jake. He's trying to cloud your title, make it look like there's a dispute over ownership. Scares off buyers, creates leverage for him to lowball you again. It's a shakedown. Can he do that? He's doing it. The question is whether it's legal. It's not. False police reports, harassment, tortious interferences, racking up violations. But here's the thing. Richard's betting you can't afford a prolonged legal fight. Most farmers facing this either sell cheap or go broke defending their title. He's done this before and won. But you need to document everything. I've been showing cops my deed. That's it. Not enough. Start a file. Every time they show up, get the deputy's name, badge number, report number. Request copies of the complaints Richard filed. Build a timeline. When we hit 5 or 6 incidents, we file a lawsuit and request a restraining order. We bury him in. His own pattern? For what? Harassment, abusive process, tortious interference with property rights? And if we can prove he's doing this to force a sale, we go after him for fraud and punitive damages. I hung up and opened a new folder on my laptop. Richard Voss's false police reports for incidents so far. For deputies. Started typing. Dates, times, names, badge numbers, exact wording of complaints. Paul was right. I needed documentation because this wasn't stopping, and I wasn't selling, not to Richard. Not for $500,000, not for any price. This was Grandma's land. The place I'd learned to drive a tractor at 12. Fields I'd helped harvest every summer. 30 years of her and Grandpa's work. 48 years of family ownership. I could have sold to Hartman for $9 million and bought a dozen quiet farms anywhere in the country. But this one was mine, and I was going to fight for it. The 5th call came 3 days later. Deputy Williams knocked on my door at 6:47 a.m. on a Friday. Mr. Daniels, we've received another complaint. I know. Richard Voss called again. Claimed I'm trespassing. I'm not. This is my land. I inherited it 7 years ago. Here's my deed. Here's the survey. Here's the tax assessment showing continuous family ownership since 1977. I handed him a folder I'd prepared the night before. Everything documented, organized, clear. Deputy Williams flipped through it. Sir, why does this keep happening? Because the HOA president wants to buy my land for $500,000. It's appraised at $9.2 million. I refused his offer now. He's harassing me with false police reports to cloud my title and scare off other buyers. It's a shakedown. Williams looked at the deed, then at me. You want to file a counter-complaint? Yes. 4. False reporting, harassment, abuse of process, whatever applies. He wrote it down. I'll file it with the sergeant, but I'll be honest, county doesn't prioritize these unless there's a clear pattern. Deputy, this is the 5th call in 3 months. How much more of a pattern do you need? Noted. I'll include that in my report. He left. I stood in the doorway watching his car disappear down the gravel road that cut through my soybeans. 5 calls, 5 visits, 5 disruptions, all because I wouldn't sell my inheritance for 1/18 of its value. I walked back inside, opened my laptop, and added the 5th incident to the file. Then I started researching Richard Voss development, projects, property acquisitions, business partnerships, lawsuits. If he wanted a fight, I'd give him one. But I was going to win. I spent that weekend building a case file, not just on the police calls on Richard Voss. Paul had said Richard was betting I couldn't afford a legal fight, that he'd done this before, that farmers either sold cheap or went broke defending their land. I wanted to know how many times he'd done it, and how he'd gotten away with it. I started with public records, Monroe County Property Database, tax assessor records, deed transfers, business registrations, court filings, Voss development. Group had been incorporated in 2010. Richard was sole owner and registered agent. 15 years in business, it's just like he'd said. But the property acquisitions told a different story. In the past 5 years, Voss Development had purchased 11 parcels of agricultural land in Monroe County, all of them within 3 miles of the new I-94 interchange, all of them bought between 2020 and 2024. Right as the highway expansion plans became public, all of them purchased for 30 to 50%, low appraised value. I cross-referenced the sellers. 8 were longtime farmers. 3 were estates selling inherited land. I recognized 2 names, Martin Kowalski and Sandra Hewitt. Both had farms near mine. Both had sold to Richard in the past 2 years. Martin first. I called him Saturday afternoon. Martin, it's Jake Daniels, Dorothy's grandson. I'm living on her farm now, Jake. Good to hear from you. How's the place holding? Up good. Listen, I have a question. You sold your land to Richard Voss in 2023, right? Long pause. What? Yeah. 83 acres. Why? What made you sell? Another pause. Longer this time. Watch, Jake, I don't want to get into it. Martin Richard offered me $500,000 for land worth $9 million. I refused. 2 weeks later, he started calling the cops on me, claiming I'm trespassing. On my own property, this is the 5th time in 3 months. I think he's trying to harass me into selling cheap. Martin exhaled slowly. That son of a bitch. What happened? Started in April 2023. Fire marshals showed up, said they'd received an anonymous complaint about my burn barrels. I'd been burning field waste the same way for 30 years. Never had a problem. Fire marshal came out 3 times in 6 weeks. 3rd time, he issued a citation. $2,500 fine. 4 burned barrels. Yeah. Then the health inspector showed up. An anonymous complaint about my septic system. They made me dig it up and replace it. Cost me $18,000. Then the code enforcement officer came out. Anonymous complaint about junk vehicles on my property. I had 2 old tractors I was fixing up. They made me remove them or face daily fines. I was writing this down as fast as I could type. How long did this go on? 4 months. Every 2 weeks. Some new complaint. New inspector? New fine. By August, I'd spent $35,000 dealing with violations I'd never had in 40 years of farming. Then Richard showed up. Said he'd heard I was having trouble with the county. Offered to buy my land, $3.2 million for 83 acres. What was it worth? $5.8 million? But I was exhausted. Broke. My wife was furious. We couldn't afford more fines, so I sold. Did you ever find out who filed the complaints? No. All anonymous. But every single complaint came within a week of Richard stopping by to check on how I was doing. He'd show up, ask if I'd reconsidered selling. I'd say no, and then boom, another inspector. Do you think he was filing the complaints? I know he was. I just couldn't prove it. I thanked Martin and hung up. Then I called Sandra. Hewitt? Sandra's story was nearly identical. She'd inherited 112 acres from her father in 2022. Land appraised at $7.4 million. Richa offered her $2.1 million in March 2023. She refused. 2 weeks later, anonymous complaint to the county about illegal dumping on her property. There was no dumping. Didn't matter. The county sent an inspector. She had to pay for a hazardous materials assessment. Cost $4,200. 3 weeks after that, anonymous complaint about unpermitted grading and drainage work. She'd hired a contractor to fix erosion on the northern boundary. The contractor had the permits, didn't matter. The county froze the project, made her submit new applications. Fined her $3,000 for work completed without updated permits. 6 weeks. After that, anonymous complaint about abandoned structures. 2 old barns her father had built in the 1980s. County said they violated current building codes, ordered them demolished or brought up to compliance. Cost $22,000 to demolish. By December 2023, Sandra had spent $29,000 fighting violations. Richard made another offer, $2.5 million. She took it. I didn't want to sell, Sandra said, but I couldn't afford to keep fighting. And every time I talked to Richard, he'd mention how much easier it would be if I just sold to him. He knew exactly what was happening. He was behind it. Did you ever report it? To who? The complaints were anonymous. The inspectors were just doing their jobs. I couldn't prove Richard was involved. And by the time I figured out the pattern, I'd already signed the sale agreement. I hung up and stared at my notes. Martin and Sandra, 2 farmers, 2 identical patterns, anonymous complaints, inspectors, fines, financial pressure. Lowball offers. From Richard, both sold for 40 to 55% below market value, and Richard walked away with land worth $13.2 million combined. Purchased for $5.7 million total, $7.5 million. Profit just from harassing people into selling cheap. I kept digging. Monroe County. Court records. Civil cases involving Voss Development or Richard Voss personally. I found 3 lawsuits, all filed between 2019 and 22-1 by a farmer named Eugene Fletcher, claiming Richard had used intimidation and fraudulent misrepresentation to force a sale. The case was dismissed. Fletcher couldn't prove Richard was behind the anonymous complaints. One by an estate executor named Carol Brandt, claiming Richard had intentionally clouded title to depress property value before purchasing. Settled out of court for undisclosed terms. One by a neighboring property owner named James Holcomb, claiming Richard's construction company had repeatedly trespassed and damaged plaintiff's fencing. Settled out of court. 3 lawsuits. All settled or dismissed, but all with the same pattern: harassment, pressure, financial coercion. Richard had been doing this for at least 5 years, and he'd perfected it. Monday morning, Deputy Williams called me. Mr. Daniels, I filed your counter-complaint for false reporting. Sergeant Ramirez reviewed it. He wants to talk to you. About what? About Richard Voss? Can you come to the station this afternoon? I drove to the Monroe County Sheriff's Office at 2 p.m. Sergeant Ramirez met me in a small conference room. Was maybe 50 gray hair, tired eyes, 25 years on the job written all over him. Mr. Daniels, I've reviewed the 5 complaints filed against you by Mr. Voss. I've also reviewed the documentation you provided to Deputy Williams' deed. Survey, tax records, your ownership is clear. These complaints are false. So what happens? Now, normally, I'd call Mr. Voss, tell him to stop filing frivolous complaints, and close the case. But Deputy Williams mentioned you believe this is part of a harassment campaign related to a property sale dispute. It is. Richard offered me $500,000 for land worth $9 million. I refused. 2 weeks later, the police call started, and I'm not the first. He's done this to at least 3 other landowners in the past 5 years. Harassed them with anonymous complaints, forced them to spend thousands on fines and compliance, then bought their land cheap when they couldn't afford to keep. Fighting. I slid my research across the table. Martin's story, Sandra's story, the lawsuits, the property acquisitions. Ramirez read through it carefully, taking his time. Mr. Daniels, this is troubling. But here's the problem. I can't prove Richard filed those complaints. They were anonymous. And the complaints filed against you don't name him directly. They come through the Meadowbrook HOA, she happens to be president of. Legally, he can claim he's acting on behalf of the HOA, not personally, but it's the same pattern. He makes an offer, I refuse, and then the harassment starts. I believe you, but belief isn't evidence. If we're going to stop him, we need proof he's filing false reports knowingly and intentionally. Right now, all we have is a pattern. So what do I do? Ramirez leaned forward. Document everything, every call, every visit. Every interaction with Richard. If he contacts you again, record it if you can. Virginia's a one-party consent state. So you're legally allowed. And if you have the resources, hire an attorney and file a civil lawsuit. That's where you'll get discovery. That's where you can subpoena his communications, his phone records, his emails. That's where you'll find the proof. I already have an attorney. Good, use him, because Richard Voss has been playing this game for years, and he's good at it. But he's not invincible. He's leaving a trail. You just need to follow it. I thanked him and left. On the drive home, I called Paul. Paul, I need to file a lawsuit. Martin Kowalski and Sandra Hewitt both sold to Richard after being harassed with anonymous complaints. I found 3 other lawsuits with similar patterns. And Sergeant Ramirez says the only way to get proof is through discovery. What kind of timeline are we talking? 5 police calls in 3 months? At least 2 confirmed victims willing to talk. 3 prior lawsuits showing pattern and practice. That's enough. We'll draft the complaint this week. We'll file for harassment, abuse of process, tortious interference, and intentional infliction of emotional distress. And we'll request expedited discovery on all communications between Richard and the sheriff's office, the county inspectors, and the Meadowbrook HOA board. How much will this cost? $15,000 to $20,000 to start? More if it goes to trial, but if we win, we recover fees and potentially punitive damages. Do it. I hung up and pulled into my driveway. The soybeans were golden in the late afternoon sun, ready for harvest in a few weeks. The farmhouse looked solid, peaceful, exactly like it had when Grandma was alive. This was my land. Richard Voss had tried. To steal it from Martin? From Sandra? From at least 3 others? He thought he could do the same to me. But I wasn't broke. I wasn't exhausted. And I wasn't selling. I walked inside, opened my laptop, and started drafting a timeline of every interaction. With Richard, every offer, every police call, every threat. Paul would file the lawsuit, Ramirez would watch for more complaints, and I would document every single move Richard made, because he wasn't done. I knew that. Men like Richard didn't give up after 5 tries. He'd keep pushing, keep harassing, keep trying to break me. I just needed to be ready when he made his next move. The 6th police call came 8 days later, but this time it wasn't about trespassing. It was about something worse, and that's when I realized Richard had been holding back. The real harassment was just beginning. The 6th call came on a Wednesday morning, October 16th. But this time it wasn't a deputy at my door. It was a code enforcement officer from Monroe County Planning and Zoning. Mr. Daniels. I'm Officer Patricia Marsh. We've received a formal complaint from the Meadowbrook HOA, alleging you've blocked a historic community access easement across your property. I need to inspect the alleged easement and verify compliance. With county code, I stared at her. There is no easement on my property. The HOA has submitted documentation claiming a pedestrian access easement was granted in 1985. It's predating your ownership. If that's accurate, you're required to maintain access. Blocking an easement is a violation of County Code 14-207. There is no easement. My grandmother bought this land in 1977. She never granted access to anyone. I inherited it 7 years. I've reviewed every document in the title chain. There's no easement. Officer Marsh pulled out a folder. The HOA submitted this. She handed me a photocopy of a document titled Community Access Agreement, Meadowbrook Development, 1985. It was 2 pages, typed on what looked like an old typewriter, signed at the bottom with a signature that was supposedly my grandmother's, the document claimed. Dorothy Daniels had granted a perpetual pedestrian easement across the northern boundary of her property, allowing residents of the future Meadowbrook development to access the county trail system. I read it twice. This is fake. Excuse me? This document is fake. First, Meadowbrook wasn't developed until 2023. This is dated 1985. 38 years before the subdivision existed. Second, my grandmother would never have signed this. Third, this signature doesn't match her actual signature. I pulled out my phone, opened the photo of Grandma's will from 2019. Her signature was clear, distinctive, a looping D, sharp tail on the S of Daniels. The signature on the easement document was completely different. Blocky letters. Wrong slant. This is forged. Officer Marsh looked uncomfortable. Mr. Daniels, I'm not here to determine authenticity. I'm here to verify whether an easement exists and whether you're in compliance. The HOA submitted this document as evidence. If you dispute it, you'll need to address that through the county recorder's office or the courts. When did they submit this? Yesterday. The complaint was filed Tuesday afternoon. 8 days after I'd filed the counter-complaint with Sergeant Ramirez. 8 days after Richard knew I was building a case against him. Officer Marsh, this is retaliation. Richard Voss has been harassing me for 4 months because I won't sell my land to him. He's called the police on me 5 times with false trespassing claims. Now he's submitting forged documents to the county. This is fraud. That's between you and the HOA, sir. My job is to inspect the property and determine compliance.
Yeah.
Access the northern boundary. I let her walk the property. There was no path, no trail, no indication anyone had ever used the northern boundary for access. Just soybeans and a barbed wire fence separating my land from the county road. Marsh took photos, made notes, and left. I'll submit my report to the county within 5 business days. If the easement is determined to be valid, you'll be required to remove any obstructions and restore access. If you dispute the easement, you can file an appeal with the county recorder. He handed me a copy of the complaint and drove off. I stood in the driveway, holding the forged document, my hands shaking. Richard had just escalated from police harassment to document fraud. I called Paul immediately. Paul, Richard just submitted a forged easement document to the county. Claims my grandmother granted pedestrian access in 1985 for a development that didn't exist until 2023. The signature's wrong. The whole thing is fake. Send me a copy. Now, I scanned the document and emailed it. Paul called back 10 minutes later. Jake, this is bad. Bad how? Richard's not just harassing you anymore, he's clouding your title. If the county records this document, temporarily it creates a legal question about your property rights. That'll show up in title searches. Hartman and Associates won't touch your land with a clouded title. No lender will finance a purchase. No buyer will close. But it's fake. The signature doesn't match. Meadowbrook didn't exist in 1985, I know. But here's the problem. Proving it's fake takes time. We'll need a handwriting expert. We'll need to pull every deed, every document your grandmother ever signed. We'll need to subpoena the HOA's records to find out where this document came from. That's months of litigation. And in the meantime, your title is clouded. So Richard wins. Not if we move fast. I'll file an emergency motion to block the county from recording this document. I'll attach your grandmother's will, her actual signature, and a declaration from you stating the easement never existed. I'll request a hearing within 2 weeks. But Jake, this is going to cost money. Expert witnesses, court fees, discovery. We're looking at $30,000 to $50,000 if this goes to trial. Do it. Are you sure? Because Richard's betting you'll give up? That you'll decide it's cheaper to sell to him for $500,000 than to spend $50,000 fighting him. Not selling. Good. I'll file the motion today. I hung up and sat down at the kitchen table, staring at the forged document. Richard had just committed fraud, and he'd done it in writing. That was his mistake. The story hit the local news 2 days later. Greedy air blocks, community access. HOA claims the article in the Monroe County Gazette was short, one-sided, and damning. The Meadowbrook Homeowners Association filed a formal complaint this week alleging that landowner Jake Daniels has blocked a historic pedestrian easement across his 47-acre property. The easement, granted in 1985, provided community access to county trails. Daniels, who inherited the property in 2019, has reportedly refused to honor the agreement. This easement has been in place for nearly 40 years, said Meadowbrook HOA. President Richard Voss. Mr. Daniels is trying to erase a long-standing community right for his own financial gain. We're asking the county to enforce the easement and restore access for families who've used this path for decades. Daniels could not be reached for comment. I threw the newspaper across the room. They hadn't called me, hadn't asked for my side. Just printed Richard's lies as fact. I called the Gazette and asked for the reporter, Emily Tran. Ms. Tran, I'm Jake Daniels. You wrote an article about the easement dispute on my property. You said I couldn't be reached for comment. You never called me. Mr. Daniels, I called the number listed on the HOA complaint. You went to voicemail. What number? She read it off. It wasn't my number. It was off by 1 digit. That's not my number. Someone gave you the wrong contact information. I apologize. Would you like to provide a statement now? Yes. The easement Richard Voss submitted to the county is fake. It's dated 1985, but Meadowbrook didn't exist until 2023. The signature is forged. It doesn't match my grandmother's actual signature. Richard has been harassing me for 4 months because I refused to sell my land to him for a fraction of its value. This easement claim is fraud, and I'm filing a lawsuit to prove it. Emily was silent for a moment. Do you have evidence the signature is forged? Yes, I have my grandmother's will, signed in 2019. The signatures don't match. I'm hiring a handwriting expert to confirm it. Can you send me copies? I'll have my attorney send you a statement with supporting documents. I'll run a follow-up. But Mr. Daniels, if the easement is recorded with the county, it's going to be hard to undo. Even if it's fake, the legal process takes time. I know. That's what Richard's counting on. I hung up and called Paul. Paul, the Gazette ran a story. Richard's spinning this as greedy air blocks community access. They're making me look like the bad guy. Let them. We'll respond through the courts. I filed the emergency motion this morning. Hearing is scheduled for October 30th, 2 weeks. From now, I've also subpoenaed the Meadowbrook HOAS records. If Richard created that document recently, there'll be a digital trail. Emails, drafts, metadata. We'll find it. What if we don't? Then we rely on the handwriting expert. I've already contacted one Dr. Laura Simmons, forensic document examiner. She'll compare the easement signature to your grandmother's known signatures. If it's forged, she'll testify. How much? $8,000 for analysis and testimony. Do it. Paul paused. Jake, you're in for over $20,000 already? If this goes to trial, you could be looking at $60,000 total. Are you prepared for that? Richard forced 3 farmers to sell their land cheap by harassing them into bankruptcy. I'm not letting him do that to me. Whatever it costs, I'll pay it. All right, I'll keep pushing. Over the next week, I watched the story spread. The Gazette article got picked up by 2 regional news sites. The headline morphed. Landowner accused of blocking historic trail access. The Meadowbrook HOA posted about it on their Facebook page. Muscled free comments, most of them angry. This guy inherited land, and now he thinks he owns the whole county. Typical rich outsider. Doesn't care about the community. Been using that trail for years. Can't just take it away. I wanted to respond. To tell them I wasn't blocking anything because there was no trail, that Richard was lying, that the easement was forged. But Paul told me not to engage. Let them say whatever they want. We'll respond in court. Anything you post online can be used against you. So I stayed quiet, and I watched Richard win the PR battle by October 25th. I'd received 3 messages from neighbors I didn't know, accusing me of destroying community trust. Someone left a note on my truck. Greed isn't a good look. Back. The pressure. Was working not on MIA. Wasn't selling, but on my reputation. On the community perception. On the likelihood that anyone other than Richard would want to buy my land after this mess. That's what he wanted. Isolate me. Make me toxic. Make the land undesirable to other buyers. Then swoop in with another lowball offer. $750,000, Jake. No, there are title issues, but I'm willing to take the risk. This is the best offer you're going to get. Except he'd made one mistake. He'd put his fraud in writing, and I was going to use it to bury him. The hearing was scheduled for October 30th at 10 a.m. In Monroe County Circuit Court, Paul filed our motion to block the easement recording. Attached, my grandmother's will, her signature samples, and my declaration that no easement had ever existed. Richard's attorney, David Chen, filed a response arguing the easement was valid, recorded in good faith, and supported by decades of community use. The night before the hearing, Paul called me. Jake, I got the HOA's subpoenaed records. You need to see this. What did you find? The easement document was created on Richard's personal computer on September 28th, 3 weeks ago. Oh, not 1985. 3 weeks ago. The metadata still embedded in the file. He used Microsoft Word Times New Roman font and saved it as easement_draft_final.docx. Quotes. I felt my heart pounding. He forged it, and we can prove it. Does his attorney? No, not yet. I'm bringing it to the hearing tomorrow. This is case on an evidence, Jake. Richard just handed us everything we need. I hung up and walked outside, staring at the dark fields. Richard had been so confident. So sure he could bully me into selling. He'd harassed me with police calls. Filed false complaints. Forged an easement. Turned the community against me. But he'd gotten sloppy. And now I had him. The hearing was tomorrow, and Richard Voss was about to learn what happened when you tried to steal from someone who fought back. The hearing, on October 30th, lasted 43 minutes. Judge Patricia Holbrook presided. She was in her early 60s, appointed to the bench in 2012. Known for no-nonsense rulings and zero tolerance for procedural games, Paul presented our motion first. Your Honor, the plaintiff seeks to block the recording of a fraudulent easement document submitted by the Meadowbrook HOA. The document claims to be from 1985 but was actually created 3 weeks ago on the personal computer of HOA President Richard Voss. We have metadata proving the creation date, and we have handwriting analysis proving the signature attributed to Dorothy Daniels is forged. He submitted the expert report from Dr. Laura Simmons. She'd compared the easement signature to 15 known samples of Grandma's signature from her will, property deeds, tax returns, bank documents. Her conclusion: the signature on the alleged 1985 easement document is inconsistent with Dorothy Daniels' authentic signature in stroke pressure, letter formation, and slant angle. It is my professional opinion that the signature is a forgery. Paul then submitted the metadata report from a digital forensics analyst named Marcus Webb. Filename easement_draft_final.docx created September 28, 2025. 11:47 p.m. Last modified. September 29, 2025. 9:14 a.m. Author Richard Voss Software. Microsoft Word 2021. Judge Holbrook read both reports carefully. Then she looked at David Chen, Richard's attorney. Counselor, your client submitted a document to the county claiming it was created in 1985. The metadata shows it was created 3 weeks ago. How do you explain that? David Chen looked like he'd been hit with a brick. Your Honor, I was not aware of this discrepancy. The client represented to me that this document was authentic and historical. I will need time to consult with my client. Your client committed fraud, Counselor. He forged a signature, backdated a document, and submitted it to a government agency to cloud the plaintiff's title. That's not a discrepancy. That's a crime. She turned to Paul. Motion granted. The county is enjoined from recording the easement document. Mr. Daniels' title is clear. Costs awarded to the plaintiff. She banged the gavel. Mr. Chen, I'm referring this matter to the Monroe County District Attorney for investigation of forgery and fraud. Your client should retain criminal counsel. Richard sat in the gallery, pale and silent. We walked out of the courtroom and Paul turned to me. You just won. Clear title costs. And Richard's about to be criminally investigated. Is this over? For the easement? Yes. But Jake, he's not going to stop. Men like Richard don't quit just because they lost in court. We'll try something else. Let him. I drove home feeling lighter than I had in months. The forged easement was dead. My title was clear. Richard was facing criminal investigation, but Paul was right. It wasn't over. The next move came faster than I expected on November 3rd. For days after the hearing, I was walking the northern boundary of my property when I saw it. A brand new chain link fence, 6 feet tall. Heavy gauge steel. It's running east to west across the back section of my land. It wasn't on the property line. It was 200 feet inside my property. I stood there, staring at it, my pulse hammering. Someone had installed a fence on my land, without permission. Without notice, I pulled out my phone and took photos. Then I called the surveyor who'd mapped my property 7 years ago when I inherited it. Tom, it's Jake Daniels. I need you out here today. Someone just put a fence 200 feet inside my northern boundary. I need documentation showing it's on my land. Tom arrived 2 hours later with his crew. He spent 90 minutes taking measurements comparing to the original survey, confirming what I already knew. The fence was 197 feet south of my actual property line. It cut off 4.2 acres of my land. Tom handed me the updated survey. Jake, whoever installed this knew exactly what they were doing. This isn't a mistake. They're claiming your land. Who owns the land on the other side of my property line? Tom checked his records. County road right-of-way on the north. And to the northwest? Looks like it's owned by an LLC. Meadowbrook Properties Holdings. When was that LLC formed? Not sure. You'd have to check with the Secretary of State. I drove straight to the Monroe County Sheriff's Office and filed a trespassing complaint. Sergeant Ramirez took the report personally. Mr. Daniels, you're telling me someone installed a fence 200 feet inside your property without your permission? Yes, and I think it's connected to Richard Voss. The land on the other side is owned by an LLC called Meadowbrook Properties Holdings. I'd bet anything Richard owns that LLC. I'll send a deputy to document it. But Jake, this is a civil property dispute now, not a criminal trespass. You'll need to file a lawsuit to get the fence removed. I'm already suing him for harassment and fraud. I'll add this to it. Good, because he's escalating. First the police calls, then the fake easement. Now a fence on your land. It's trying to provoke you. It's working. That night I pulled business records for Meadowbrook Properties Holdings. LLC formed on October 4th, 2025. 3 weeks before the fence went up. Registered agent, sole member, Richard Voss. The LLC had purchased 22 acres of land adjacent to my northern boundary on October 9th for $340,000. Farmland. Undeveloped. Nothing on it except overgrown grass and old fence. Posts until Richard installed a new fence. 200 feet onto my land, he was claiming 4.2 acres that didn't belong to him, and he'd done it through an LLC to create legal separation from his personal liability. I called Paul. Paul, Richard just fenced off 4.2 acres of my land. He bought the property next to mine 3 weeks ago through an LLC. He then installed a fence 200 feet inside my boundary. I've got survey documentation proving it's on my land. Did he get a permit for the fence? I don't know, but I'm guessing no. But cuck with the county. If he built without a permit, that's another violation. And Jake, this is good for us. How is this good? Because he just committed trespass in a way we can prove. Forging an easement is fraud, but it's abstract. Building a physical fence on your land. That's concrete, literally. We can photograph it, survey it, show the judge exactly where it is, and exactly how much land he's trying to steal. This strengthens our case. What do? Amend the complaint, add trespass, theft of property, and tortious interference. I'll request an emergency injunction ordering him to remove the fence within 30 days. And I'll request punitive damages because at this point, Richard's conduct is willful, malicious, and oppressive. How much in punitive damages depends on what we can prove, but given the pattern fake easement, fence, harassment, we're looking at $250,000 to $500,000. Maybe more if we find worse behavior in discovery. What's discovery going to show? That's what we're about to find out. I've subpoenaed Richard's emails, phone records, financial documents, and all communications with the Meadowbrook HOA board. We're going to pull everything. In JICI guarantee, we'll find something. The amended complaint was filed on November 8th. Paul requested expedited discovery due to Richard's ongoing pattern of harassment and property theft. Judge Holbrook granted it. Discovery deadline, December 15th, trial date. 2026, Richard's attorney, David Chen, filed a motion to dismiss, arguing that the fence dispute was a good-faith boundary disagreement and didn't warrant punitive damages. Judge Holbrook denied it. Mr. Voss has already been found to have submitted a forged easement document. The plaintiff has provided survey evidence that the fence is 197 feet inside his property. This is not a good-faith dispute. Discovery will proceed. Paul served subpoenas on Richard personally, on Voss Development Group, and on the Meadowbrook HOA. We requested all emails between Richard and any county official from January 2025 to present, all communications between Richard and Meadowbrook HOA board members, financial records related to property acquisitions in Monroe County, all communications referencing Jake Daniels or the 47-acre property. Richard's attorney fought the subpoenas, claiming they were overly broad and harassing. Judge Holbrook overruled him. The plaintiff has alleged a multi-year pattern of harassment and fraud. Discovery is appropriate. Produce the documents by December 1st or face sanctions. The documents arrived on November 29th. Paul called me at 9 p.m. Jake, you need to come to my office now. I drove to his office in town. He had 3 banker's boxes of printed emails and documents spread across the conference table. What did you find? Paul handed me a printed email chain from Richard Voss to Mark Hastings, Meadowbrook HOA board member, date June 2nd, 2025. Subject: Daniels property. Mark Daniels refused the $500,000 offer. Right time to apply pressure. I'll file trespassing complaints through the HOA to create a paper trail. If we make enough noise, he'll sell cheap to avoid the headache. Worked with Kowalski and Hewitt. Should work here. I stared at the email. He admitted it, in writing. Keep reading. I flipped to the next email. From Richard Voss to Mark Hastings, date September 27th, 2025. Subject: Daniels lawsuit. Mark Daniels filed a harassment complaint with the sheriff. We need to cloud his title. I'm drafting an easement document backdated to 1985. Submit it to the county as an HOA complaint. If the easement gets recorded, Daniels' property becomes unsellable. He'll have to settle with me and another. From Richard Voss to Jennifer Cole, Voss's Development VP, date October 6, 2025. Subject: Daniels acquisition strategy. Jennifer bought the northwest parcel through Meadowbrook Properties LLC. Installing fence next week to claim 4 acres of Daniels' land. If he fights it, we'll settle and I'll offer $1.5 million for his full 47 acres, still $7 million under market. If he doesn't fight, we just stole 4 acres worth $800,000. Paul handed me a 4th email from Richard Voss to David Chen, attorney, date October 29th, 2025. Subject: easement hearing tomorrow. David, if the easement gets tossed, don't worry. I've got a backup plan. Fence goes up this week. Daniels will be buried in legal fees by Christmas. He'll sell. I looked up at Paul. He documented everything. Fraudulent easement, fence trespass, intentional strategy to harass you into selling cheap, and he admitted. He did the same thing to Martin Kowalski and Sandra Hewitt. This is criminal. It's also civil. Got him on fraud, trespass, harassment, and tortious interference. We've got his motive. We've got his plan. We've got his confession that he's done this before. What happens now? We submit this to Judge Holbrook. We request summary judgment, meaning we win without going to trial because the evidence is overwhelming. And we request $500,000 in punitive damages plus attorney fees. Will she grant it? Jake, I've been practicing law for 22 years. I've never seen evidence this clean. Richard Voss just handed us his entire playbook. We're going to destroy him. I drove home at midnight, the emails echoing in my head. Make enough noise, he'll sell cheap. Worked with Kowalski and Hewitt. If the easement gets tossed, don't worry. I've got a backup plan. Richard had thought he was untouchable. He'd been doing this for years, harassing farmers, clouding titles, forcing cheap sales, pocketing millions. And he'd gotten away with it because most of his victims couldn't afford to fight back. But he'd made one mistake. He'd gone after someone who could, and he'd documented his entire fraud in writing. I stood on my porch, looking out at the 47 acres my grandmother had left me. The fence was still there. It's cutting across the northern section like a scar. But not for long. Paul would file the motion for summary judgment. Judge Holbrook would see the emails, and Richard Voss would pay for every lie, every forged document, every foot of fence on my land. I had him now. Yeah. I just needed to make it stick. Paul filed the motion for summary judgment on December 3rd. Summary judgment meant we were asking the judge to rule in our favor without a trial because the evidence was so overwhelming that no reasonable jury could find for Richard. The motion was 47 pages long. It included survey documentation proving the fence was 197 feet inside my property metadata, proving the easement was forged 3 weeks ago, not created in 1985. Dr. Simmons' handwriting analysis proving Grandma's signature was fake Richard's emails, admitting he'd used harassment to force cheap sales from Kowalski, and Hewitt Richard's email stating, if we make enough noise, he'll sell cheap to avoid the headache. Richard's email admitting the fence was installed to claim 4 acres of Daniel's land, financial records showing Richard had profited $7.5 million from below-market acquisitions in the past 5 years. Paul requested $500,000 in punitive damages for willful malicious conduct, $68,000 in attorney fees and costs, mandatory removal of the fence within 30 days, permanent injunction prohibiting Richard from filing complaints, contacting county officials about my property, or interfering with my property rights. Richard's attorney David Chen filed a 12-page opposition. It argued the emails were taken out of context. The fence was installed in good faith based on a survey error. The easement was submitted based on information provided by HOA members who believed it was authentic. Punitive damages were excessive and unwarranted. Judge Holbrook scheduled a hearing for December 20th. The courtroom was smaller than I'd expected. Monroe County Circuit Court, Division 3. Wood paneling, fluorescent lights, 20 seats in the gallery. I sat behind Paul at the plaintiff's table. Richard sat across the aisle with David Chen, wearing a charcoal suit and a tight expression. This was the first time I'd seen him since the day he'd offered me $500,000 for my land 6 months ago. Felt like 6 years. Judge Holbrook took the bench. At 9:02 a.m. This is the motion for summary judgment in Daniels v. Voss. Mr. Greenberg, you may proceed. Paul stood. Your Honor, this case is about a calculated, multi-month campaign of harassment designed to force the plaintiff to sell his property for a fraction of its value. The defendant, Richard Voss, is a developer who has used this tactic repeatedly. Over the past 5 years, he makes a lowball offer. When the owner refuses, he uses his position as HOA president to file false police reports, submit fraudulent documents to county agencies, and install physical structures on the victim's land. To create the appearance of a title dispute and pressure the owner into selling cheap, Paul clicked a remote. A screen behind him lit up with the first email. From Richard Voss to Mark Hastings. Date June 2nd, 2025. Subject: Daniel's property, if we make enough noise, he'll sell cheap to avoid the headache. Worked with Kowalski and Hewitt. This email, Your Honor, is the defendant's own admission that he used harassment to force prior landowners, Martin Kowalski and Sandra Hewitt, to sell their property below market value. Both victims have provided declarations confirming they were subjected to anonymous complaints, county inspections, financial pressure, until they sold to Mr. Voss at 40 to 55% below appraised value. Paul advanced to the next slide. From Richard Voss to Mark Hastings. Date September 27, 2025. Subject: Daniels lawsuit. I'm drafting an easement document backdated to 1985. Submit it to the county as an HOA complaint. If the easement gets recorded, Daniels' property becomes unsellable. This email, Your Honor, shows the defendant knowingly and intentionally forged a legal document, backdated it by 40 years, and submitted it to a government agency to cloud the plaintiff's title. That is fraud. That is forgery. That is a crime. Judge Holbrook made notes, her face unreadable. Paul continued. The defendant then installed a fence 197 feet inside the plaintiff's property, claiming 4.2 acres that don't belong to him. His own email admits this was intentional. Showed the third email, from Richard Voss to Jennifer Coldate, October 6, 2025. Subject: Daniels' acquisition strategy, installing fence next week to claim 4 acres of Daniels' land. If he fights it, we'll settle, and I'll offer $1.5 million for his full 47 acres. Still $7 million under market. Your Honor, this is not a boundary dispute. This is theft. The defendant admitted he installed the fence to steal 4 acres worth $800,000. And if the plaintiff fought back, the defendant planned to use the resulting legal costs as leverage to force another below-market sale. Paul paused, letting it sink in. The plaintiff has spent $68,000 in legal fees, defending his property from a campaign of harassment, fraud, and trespass. The defendant has made millions using this tactic on other victims. The evidence is overwhelming. The defendant's own words: convict him. We request summary judgment on all counts. Punitive damages of $500,000 and a permanent injunction. Paul sat down. Judge Holbrook turned to David Chen. Counselor. David Chen stood, looking like a man trying to bail water out of a sinking ship. Your Honor, my client made serious errors in judgment. The emails reflect poorly on his decision-making, but they don't prove the plaintiff suffered damages warranting $500,000 in punitive damages. The fence was installed based on a survey my client believed was accurate. The easement document was submitted based on representations from HOA members. My client didn't personally forge any signatures. Judge Holbrook cut him off. Counselor, the metadata shows the easement document was created on your client's personal computer. The handwriting expert confirmed the signature was forged. Your client's email explicitly states he drafted the easement and backdated it to 1985. How? Do you explain that? David Chen hesitated. Your Honor, my client may have prepared a draft document based on information he believed to be accurate, Counselor. Your client wrote, I'm drafting an easement document backdated to 1985. That's an admission of forgery. He didn't say he was recreating a lost document. He said he was backdating a new document. That's fraud, Your Honor. I understand how the email reads, and the fence. Your client wrote that he was installing a fence to claim 4 acres of Daniels' land, not to mark a boundary, to claim someone else's land. How is that a good faith survey error? David had no answer. Judge Holbrook leaned forward to Counselor. I've reviewed the evidence. Your client orchestrated a campaign of harassment targeting the plaintiff for refusing to sell his property. He filed false police reports. He forged legal documents. Trespassed on the plaintiff's land. His emails show he did the same. Thing 2, at least 2 other landowners, profiting millions of dollars from forced below-market sales. This isn't a contract dispute. This is targeted harassment for financial gain. She turned to Paul. Mr. Greenberg, does the plaintiff have any additional evidence? Yes, Your Honor. We've prepared declarations from Martin Kowalski and Sandra Hewitt, both of whom were subjected to identical harassment by Mr. Voss and forced to sell their properties at 40 to 55% below market value. Their testimony corroborates the defendant's pattern and practice. Submit them. Paul handed the court clerk to bound declarations. Judge Holbrook read them in silence. Took her time. 5 minutes. 10. Then she looked up. I'm granting summary judgment for the plaintiff on all counts. Richard's face went pale. The evidence is overwhelming. Mr. Voss engaged in a deliberate, calculated campaign of harassment designed to force the plaintiff to sell his property below market value. He filed false police reports. He forged an easement document and submitted it to the county. Installed a fence 197 feet inside the plaintiff's property to steal 4.2 acres. His own emails admit his intent and his prior use of these tactics on other victims. She paused, looking directly at Richard. Mr. Voss, your conduct is reprehensible. You've used your position as HOA president and your knowledge of real estate law to prey on landowners who couldn't afford to fight back. You've made millions of dollars through fraud, harassment, and intimidation that ends today. She turned to her notes. The plaintiff is awarded $500,000 in punitive damages. The defendant is ordered to remove the fence from the plaintiff's property within 30 days or face daily fines of $1,000. The defendant is permanently enjoined from filing complaints, contacting county officials, or otherwise interfering with the plaintiff's property rights. The plaintiff is awarded $68,000 in attorney fees and costs. Total judgment, $568,000. She banged the gavel. B. The defendant is also ordered to pay restitution to Martin Kowalski and Sandra Hewitt in amounts to be determined after they file claims. And I'm referring this matter to the Monroe County District Attorney for criminal prosecution of forgery and fraud. Court is adjourned. The courtroom was silent. Richard sat frozen, staring at the table in front of him. David Chen gathered his papers and left without a word. Paul turned to me. You just won $568,000, plus the fence comes down, plus Richard's banned from ever contacting you again. Is it over for you? Yes. For Richard. He's got criminal charges coming, restitution claims from Kowalski and Hewitt, and a $568,000 judgment he has to pay within 60 days, or you can start seizing his assets. I stood up, legs shaky, heart pounding. 6 months? 6 months of police calls, forged documents, legal fees, sleepless nights, and a constant pit in my stomach wondering if Richard would win. And now it was over. I'd won not just the case, not just the money. I'd won the principle. Richard had tried to steal my land. He'd harassed me. He'd lied to the county, the community, and the courts, and he'd lost everything. We walked out of the courtroom into the December cold. Paul shook my hand. Jake, you just did something most people can't. You stood up to a bully with money, power, and a history of winning, and you beat him. I had good evidence. You had his emails. But you also had the guts to fight. Kowalski and Hewitt didn't. 3 other farmers didn't. You did. That's the difference. I drove home, the judgment order on the passenger seat, $568,000. The fence would be gone in 30 days. Richard couldn't contact me, file complaints, or come near my property ever again. And the criminal charges were coming. I pulled into my driveway and sat there for a long time, staring at the farmhouse. Grandma had left me this land 7 years ago. Richard had tried to take it, and I'd fought him off, not just for me, for Grandma. For the 30 years she and Grandpa had worked this land. For every farmer Richard had bullied into selling cheap, the judgment was justice. But it was also a warning to every developer who thought they could harass people into surrendering their property. Not everyone will break. Some of us fight back, and when we do, we win. The fence came down on January 8th, 2026. Richard missed the 30-day deadline by 2 days, so Judge Holbrook added $2,000 in contempt fines to the judgment. Total amount owed, $570,000. I stood at the northern boundary watching a crew dismantle the chain-link fence, section by section, loading it onto a flatbed truck. 2 hours later, the land was clear. Just soybeans and the original barbed wire fence marking my actual property line for 2 acres turned 47 acres whole again, Paul called that afternoon. Richard's attorney filed a notice of appeal. He's trying to reduce the punitive damages. Will it work? No. The evidence is too strong. He'll lose the appeal and rack up another $30,000 in legal fees trying. But Jake, there's something else. Martin Kowalski and Sandra Hewitt both filed restitution claims with the court. Martin's asking for $2.6 million, the difference between what Richard paid and what his land was actually worth. Sandra's asking for $5.3 million. Will they get it? Probably. Judge Holbrook already found Richard engaged in a pattern of fraud. These claims are part of the same pattern. If she grants them, Richard will owe close to $8 million total. Can he pay that? Not easily. Voss Development has assets, but most of Richard's wealth is tied up in property. If he can't pay, you and the others can force a sale of his holdings. He could lose everything, the Meadowbrook HOA held an emergency meeting on January 15th. I wasn't a member of my property, had never been part of the subdivision, but Tom Nguyen, a Meadowbrook resident I'd met during the lawsuit, called me afterward.
Jake,
You need to hear this. The board just voted 6-1 to remove Richard as president and ban him from holding any HOA position in the future. What happened? Judgment happened. The HOA's insurance company reviewed the case and determined Richard acted outside the scope of his authority when he filed the false complaints and forged the easement. That means the HOA isn't liable, Richard is, personally, but the insurance company said if the HOA kept Richard in any leadership role, they'd cancel the policy. So the board had no choice. They removed him. How'd he take it? He didn't show up to the meeting. Resigned by email an hour before it started. Effective immediately, I resign as president and board member. That's it. No apology, no explanation. He's done. Good. Jake, people here are pissed, not at you, at Richard. You filed those complaints under the HOA's name. You made us look like we were harassing you. Half the neighborhood thought you were some greedy heir trying to steal community land. Now they know Richard lied to all of us. He used the HOA as a weapon to run his scam. People are talking about suing him for defamation and misuse of HOA authority. Would they win? Maybe, but honestly, after the restitution claims and your judgment, there won't be much left to take. The criminal charges came faster than I expected. On January 22nd, the Monroe County District Attorney filed for felony counts against Richard Voss. Forgery, creating the fake 1985 easement. Fraud, submitting the forged document to the county, filing a false report. The 5 police complaints. Theft by deception. The scheme to acquire property through harassment. Paul called me the day the charges were announced. Jake, this is bigger than your case now. The DA is treating this as a white-collar fraud investigation. They're looking at every property Richard acquired in the past 10 years. If they find more victims, he could be facing 20 years in prison. Will he go to trial? Probably not. Attorney will negotiate a plea, but he's done. His development company is finished. His reputation is destroyed. And he's looking at prison time plus $8 million in restitution. By mid-February, I'd made a decision. I was selling the land, not to Richard. Not for $500,000, but to a developer who'd approached me in early January, Hartman and Associates, the same company that had offered me $8 million a year ago. They'd followed the case. They knew my title was clear, and they were ready to move. Their offer, $9.8 million for all 47 acres. The plan, mixed use, commercial development, retail space, office buildings, light industrial. Estimated 300 jobs when fully built out. Groundbreaking projected for summer 2026. I met with Hartman's CEO, Laura Hartman, at a coffee shop in town. Mr. Daniels, I want to be clear. We're not trying to take advantage of your situation. We're offering fair market value. Your land is perfectly positioned for the I-94 corridor. We've wanted it for 2 years. Richard Voss wanted it too, but he tried to steal it. We're offering to buy it. Why didn't you make a move when Richard was harassing me? Because your title was clouded. The fake easement, the fence dispute, it made the property too risky. Banks won't finance a project on land with title questions, but now your title is clean. Judge Holbrook's ruling confirmed it. We can move forward. I thought about it. Thought about Grandma. Thought about the 30 years she and Grandpa had farmed this land. But I also thought about what the land could become. 300 jobs. Economic growth. A legacy bigger than soybeans. I'll take the offer. But I want something in the development. What? Name the main road through the development, Dorothy Daniels Drive. After my grandmother. She owned this land. For 48 years, she deserves to be remembered. Laura smiled. Done. We shook hands. Closing was set for March 15th, 20-6. The news spread fast. The Monroe County Gazette ran the story on February 20th. Harassment victim sells land for $9.8 million. Development to bring 300 jobs. The article detailed the lawsuit, Richard's fraud, and the upcoming development. It quoted Laura Hartman. This project will transform the I-94 corridor and provide significant economic benefits to Monroe County. We're grateful to Mr. Daniels for working with us to make it happen. It also quoted me. This land has been in my family for 48 years. Grandmother loved it. I'm glad it's going to be used for something that benefits the whole community. Stolen by a developer who thought he could bully me into selling cheap. The article ended with an update on Richard's legal troubles. Richard Voss is currently facing 4 felony charges and over $8 million in restitution claims. His development company has ceased operations. He has been removed as president of the Meadowbrook HOA. A trial date has not been set. I put the newspaper down and looked out at the land. $9.8 million after legal fees, taxes, and closing costs. I'd net about $7.2 million. For land Grandma had bought for $18,000. For land Richard had tried to steal for $500. Oh, it felt surreal. On March 1st, Paul called with an update. Jake, Richard's attorney, reached out. He wants to settle the judgment before you start seizing assets. He's offering $570,000, paid in full by March 31st. Can he actually pay it? Selling properties, pulling from retirement accounts, borrowing from family. He's desperate to avoid asset seizure because if you force a sale of Voss Development's holdings, he loses everything. If he pays voluntarily, he keeps some control. Tell him I want payment by March 20th, not March 31st, and if he's one day late, we seize assets. Done. The payment came through on March 18th, $570,000. Wired to my attorney's trust account, Paul deducted his fees, $68,000. Already awarded by the court, and transferred the remaining $502,000 to me, combined with the $9.8 million sale. I was looking at over $10 million in total recovery for defending land that was already mine. But Richard's problems were just beginning. On March 10th, Judge Holbrook granted Martin Kowalski's restitution claim in full, $2.6 million. On March 12th, she granted Sandra Hewitt's claim, $5.3 million. Total restitution owed, $7.9 million. Richard's attorney filed for an extension, arguing his client needed time to secure financing. Judge Holbrook denied it. Mr. Voss engaged in systematic fraud for financial gain. He profited millions of dollars by stealing from landowners who couldn't fight back. He will pay full restitution within 90 days, or I will authorize the plaintiffs to seize and liquidate his assets. Martin and Sandra both hired collection attorneys. April 2nd, they filed liens against every property Voss Development owned, 11 parcels totaling 240 acres. On April 15th, they filed a motion to force a public auction of Richard's properties to satisfy the judgment. Judge Holbrook granted it. The auction was scheduled for June 1st, 20-6. Paul called me the day the auction was announced. Jake, Richard's going to lose everything, his company, his properties, his reputation, and he's still facing 4 felony charges. The DA's office is pushing for a plea deal, 5 years in prison, $500,000 in fines, permanent ban from real estate development. Will he take it? He doesn't have a choice. If he goes to trial, he's looking at 20 years. The evidence is overwhelming. He'll plead out, serve 3 to 5 years, and come out broke and unemployable. Good. I didn't feel vindictive saying it, just ... satisfied. Richard had built a career on bullying people. He'd made millions, stealing land from farmers who couldn't afford to fight back. He'd tried it on me, and he'd lost everything that wasn't revenge. That was justice. The closing on my land happened on March 15th, exactly as planned. I signed the paperwork at Paul's office. Laura Hartman signed for Hartman and Associates. The wire transfer hit my account 30 minutes later. $9,823,000. After taxes and fees, I'd net $7.2 million. I was 43 years old, retired from corporate finance, and now independently wealthy, because I'd fought back. I walked out of Paul's office into the bright March afternoon, drove out to the farm one last time. The land was technically Hartman's now, but construction wouldn't start for another 2 months. For now, it was still just soybeans and open sky. I stood on the porch of the old farmhouse, looking out at the 47 acres Grandma had left me. She'd bought it for $18,000 in 1977. She'd worked it for 42 years. She'd left it to me. And I'd turned it into $10 million, $9.8 million from the sale, plus $570,000 from Richard's judgment. But more than that, I'd protected it from a man who thought he could take it through lies, harassment, and fraud. I'd stood up to him. I'd fought back, and I'd won. Not just for me, for Grandma, for Martin, and Sandra, for every farmer Richard had ever bullied. The land would become something new now. Roads and buildings and jobs, but it would carry Grandma's name. Dorothy Daniels Drive. A legacy that would outlast both of us. I locked the farmhouse door for the last time and drove away. Richard Voss had tried to steal my inheritance. Instead, he'd lost everything. And I'd made sure no one would ever forget why. The auction of Richard Voss's properties took place on June 1st, 2026, on the steps of the Monroe County Courthouse. Sunny morning, 72 degrees, 23 registered bidders. Didn't attend. Paul went on my behalf to observe. He called me that afternoon. Jake, it's done. All 11 properties sold. Total proceeds, $8.4 million. After auctioneer fees and liens, Martin gets his $2.6 million. Sandra gets her $5.3 million. And there's about $300,000 left over, which will go toward Richard's legal fees and fines. So he's wiped out completely. Voss Development is being dissolved. Richard's personal assets, house, cars, retirement accounts are all being liquidated to cover the criminal fines and remaining legal fees. He'll come out of this with nothing. What about the criminal case? Plea deal was finalized yesterday. Richard pled guilty to 2 counts, forgery and fraud. The other charges were dropped as part of the agreement. Sentencing is set for July 15th. DA's recommending 4 years in state prison, $250,000 in fines, and a permanent ban from holding any real estate license or forming a development company in Virginia. For years. Could have been 20 if he'd gone to trial, but yeah, for years is the deal. He'll serve at least 2.5 with good behavior. He'll be 61 when he gets out. Broke, unemployable, and barred from the industry he spent 30 years building. I hung up and sat on the porch of the small house I'd bought in Oproa, quiet place on 2 acres outside Charlottesville. An hour from Monroe County, Richard Voss had tried to steal my grandmother's land. Now he'd lost everything. His company, his properties, his freedom, and I'd walked away with $10 million. Justice wasn't always poetic, but sometimes it was exact. The fallout didn't stop with Richard. In late April, 3 more landowners came forward, people who'd sold property to Richard between 2018 and 2022, all claiming they'd been subjected to similar harassment. One was a 74-year-old widow named Helen Briggs. She'd sold 63 acres to Richard in 2021 for $1.8 million. After facing 8 months of anonymous complaints about unsafe structures on her property, 2 barns her late husband had built in the 1990s. The land was later appraised at $4.2 million. Richard had profited $2.4 million from her sale alone. Another was a retired teacher named David Morton. He'd sold 48 acres in 2024 $1.1 million. After the county cited him for illegal grading based on an anonymous complaint, His land was worth $3.1 million. Richard's profit, $2 million. The third was an estate executor named Grace Chen, who'd sold 71 acres of inherited farmland in 2018. For $900,000 after Richard convinced her the property had unresolvable wetland. Restrictions? It didn't. The land was worth $2.8 million. Richard's profit, $1.9 million. All three hired attorneys. All three filed civil suits against Richard personally, citing fraud, misrepresentation, and elder abuse in Helen's case. By May, Richard was facing an additional $6.3 million in claims on top of the $7.9 million he'd already paid to Martin and Sandra, but there was nothing left to take. Richard's properties were gone. His company was dissolved. His personal assets were liquidated. The plaintiff's attorneys reached out to the Virginia Attorney General's office, arguing that Richard's conduct constituted a pattern of consumer fraud under state law. The AG opened an investigation in June. The AG's findings were released on August 12, 2006. The report detailed Richard's schemes across 10 years, 15 victims, and $14.7 million in ill-gotten profits. It concluded, Richard Voss operated a systematic fraud enterprise designed to depress property values through harassment, false complaints, and document forgery, then acquire properties at below-market prices. His victims were predominantly elderly, rural landowners with limited financial resources to fight back. This conduct violates Virginia Consumer Protection Act sections 59.1 to 259, 1 to 204. The AG's office negotiated a settlement with Richard's attorneys. Richard agreed to pay $2.1 million in restitution to victims who hadn't yet filed lawsuits funded by liquidating his last remaining assets, including his house and pensions, surrender his real estate broker's license, permanently admit to violations of the Consumer Protection Act in a signed affidavit, cooperate with any future investigations into his business practices. The settlement was finalized on September 3rd. Helen, David, and Grace each received partial restitution, about $700,000 each, roughly a third of what they'd lost. It wasn't full justice, but it was something, and Richard had nothing left to give. The Monroe County Gazette ran a follow-up story on September 15th, disgraced developer sentenced to 4 years. Victims recover millions. The article summarized the case. Richard Voss sentenced to 4 years in state prison for forgery and fraud. $10.5 million paid in restitution to 8 victims, including Martin, Sandra, Helen, David, Grace, and others. Voss Development dissolved. All property sold at auction. Richard, personally bankrupt. Barred from real estate industry for life. State ag investigation led to Consumer Protection Act violation settlement. Article quoted Martin Kowalski. Richard Voss stole my family's farm. I'm glad he's in prison. I'm glad I got my money back. But I'll never get back the 40 years my father spent working that land. It quoted me. Richard thought he could bully me into selling my grandmother's land for $500,000. Instead, I sold it for $9.8 million, won a $570,000 judgment against him, and helped expose a decade-long fraud scheme. I'm glad I fought back. I just wish more people had been able to. The article ended with a statement from the AG's office. This case should serve as a warning. Property owners facing harassment or pressure to sell should document everything and consult an attorney. Developers who use intimidation, fraud, or forgery will be prosecuted. I framed the article and hung it in my home office, next to the deed for Grandma's land and the court judgment awarding me $570,000. Reminders, not of the fight, but of the principle that property rights matter, that bullies don't always win, that sometimes, if you stand your ground and refuse to break, you can beat someone with more money, more power, and more experience. You just have to be willing to fight. By October 2026, my life had transformed completely. I was 43 years old, retired, and financially independent. The $9.8 million from the land sale, plus the $570,000 judgment, minus taxes and fees, left me with $7.95 million in liquid assets. I bought the 2-acre property in Charlottesville, a small house, a workshop, a garden, quiet, peaceful, everything I'd wanted when I moved to Grandma's. Farm 7 years ago, I spent my days woodworking, reading, hiking, traveled some, spent a month in New Zealand, 2 weeks in Scotland, funded a scholarship at the local community college in Grandma's name, the Dorothy Daniels Memorial Scholarship. For rural students, $50,000 annually, renewable forever. Donated $100,000 to the Virginia Farmland Preservation Trust. Funding legal aid for farmers facing harassment from developers. I didn't need to work again. I didn't need to prove anything to anyone. I'd fought for what was mine, won, and walked away with enough money to live comfortably for the rest of my life. But more than the money, I had something else: peace. The knowledge that I'd stood up for myself, for Grandma, for everyone Richard had bullied over the years, and I'd won. In late November, I drove back to Monroe County for the groundbreaking ceremony at the development. Site, Hartman and Associates had invited me as a guest of honor. The site was unrecognizable. It's cleared land, surveying equipment, construction trailers. The first phase retail and office space was scheduled to open in fall 2027. Laura Hartman stood at a podium in front of about 100 people, local officials, business leaders, future tenants. This development will bring over 300 jobs to Monroe County and generate millions in economic activity. But it wouldn't have been possible without the courage of one man who refused to let his land be stolen. Jake Daniels stood up to harassment, fraud, and intimidation. He fought for his family's legacy. Because of that, we're here today. She gestured to a sign behind her. Dorothy Daniels Drive, the main road through the development, just like weed. Agreed, Grandma's name, preserved forever. I stood there, staring at the sign, feeling the weight of 7 years lift off my shoulders. This was what Grandma's land had become. Not soybeans, not Richard's stolen prize, but a legacy, jobs, opportunity, a name that would outlast all of us. I drove home that evening as the sun set over the Virginia hills, thought about the day Richard had knocked on my door, offering me $500,000 for land worth $10 million. Thought about the 6 police calls. It's the forged easement, the fence on my property. Thought about the emails. If we make enough noise, he'll sell cheap. He'd been so sure, so confident that I'd break, just like Martin and Sandra and the others. But I hadn't. I'd fought back, and I'd won everything. The land. The money, the justice. Grandma had left me 47 acres of soybeans. Richard Voss had tried to steal them, and had turned them into a legacy, not just for me, for everyone he'd ever bullied, for every farmer who couldn't afford to fight back, for every person who thought they were powerless against someone with money and connections. I'd proven they weren't. You don't need power to win. You need evidence. You need patience. You need a good attorney. And you need the willingness to stand your ground, no matter how hard they push. Richard Voss spent 10 years stealing land from people who couldn't fight back. He made $14.7 million doing it. Then he tried it on me, and he lost everything. 4 years in prison, his company dissolved, his fortune gone, his name ruined. I walked away with $7.95 million, a scholarship in Grandma's name, and Dorothy Daniels Drive, running through the heart of Monroe County. That's what happens when you fight back. You don't just win, you make sure no one forgets why they lost.